Does the New York State Commissioner of Education have the authority to declare that non-public schools are not schools at all? To find out, you have to read Matter of Parents for Educational and Religious Liberty versus Young, but it's 10 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Parents for Educational and Religious Liberty in Schools versus Young. The citation for this case is 2025 New York Slip Opinion 03689, published by the New York Court of Appeals on June 18th of 2025. The issue, and it's a little complicated, but the issue in this case is whether the commissioner of the Education Department in New York has the authority, had the inherent authority, to issue new regulations that declare a school, a non-public school, to not be a school anymore. I'll get into all that in a few moments. The background that's helpful to know and appreciate the context of this case is that, first of all, under the 14th Amendment to the United States Constitution, parents have a due process right to raise their children and decide how to educate their children. At the same time, under the education law, there's a requirement in the New York State Constitution that the state provide free education for all children between the ages of 6 and 16. And parents are required to make sure that their children attend a school or get an equivalent education from a school, a substantially equivalent education that a public school would give. And there's three ways that parents can ensure their children get school: either going to the public school, going to a non-public school, think a parochial school or a gifted and talented program or a special education school, or homeschooling. Those are the three different ways. But a parochial school or a non-public school has to be substantially equivalent. And if it's not giving a substantially equivalent education to a public school, then there's a problem. And parents who fail to provide their children with substantially equivalent educations to public school are subject to either criminal prosecution or educational neglect. Parents can lose their children for them failing to make sure that they're educated pursuant to law. The other thing you have to know is that there's an education department in New York State, and there's a commissioner of the education department whose job it is to ensure that that education law is complied with, that all public schools are complying with the law, that non-public schools comply with the substantial equivalent rule, and that homeschooling also has some guidelines and some curricula limits to make sure that children, the main goal here is that children receive education that is satisfactory, minimally satisfactory for the state of New York. Okay, so the facts of this case are that because of the substantial equivalent determination requirement, there's rules that allow the education department to analyze whether non-public schools are providing that substantial equivalent education. And in 2022, the commissioner of the State Department of the Education Department promulgated 8 NYCRR Part 30, okay, which sort of outlined the consequences of failing to comply with the pathways that a non-public school can show that it's providing substantially equivalent education to a public school. And basically what that rule explained is that if a non-public school fails to adequately show that it's giving a substantially equivalent education, then it will not be considered a school anymore. Okay, the definition of school does not extend to a non-compliant, non-public school. As a result of that law passing, this lawsuit was filed. It's an Article 78 declaratory judgment action, where basically these group of, I think, 5 or 6 different non-public schools that are members of this PERLS organization, which is the Parents for Educational and Religious Liberty in Schools. I think these are mostly Jewish day schools, yeshivas, Jewish-affiliated non-public schools. They filed this Article 78 declaratory judgment action alleging basically that this exceeded the authority of the commissioner to issue these new regulations, to declare that something is not a school, because it's depriving the parents of their right to the school of their choice, which is guaranteed under the 14th Amendment, and it's closing down schools, and that's beyond the authority of the commissioner to do. That's the allegation from the plaintiffs. Ultimately, this goes to the Court of Appeals, and the Court of Appeals disagrees with the plaintiffs, says that's not what this rule is doing. The rule basically just defines what a school is. That's all it does. It's not directing parents to take their kids out of the non-compliant school. It's not saying that the parents can't educate their children the way they want. It's saying that this is not a school. All the other laws still apply where you have to provide your kid with a school or the substantial equivalent of a public school education. But the holding from the Court of Appeals here is that the commissioner is not exceeding his or her authority. The commissioner is exercising the appropriate authority to ensure compliance with the law. And all it's doing is saying this does not satisfy what a school is. And that's the case of matter of Parents for Educational and Religious Liberty in Schools versus Young. The law stands. And that's the holding. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.